Hi, everyone. I'm immigration lawyer John Khosravi. Thank you for joining us today, Wednesday, February 25th or 24th, actually. A great Wednesday, 5 p.m. Pacific. And it's great because one of the travel bans for the United States was lifted. We're going to jump into that in a second. As a reminder, we do these lives every Friday, 5 p.m. Pacific time. I'm immigration lawyer John. And it's just general education only, where I take your questions on various social media websites. So with that, let's get it started. All right, so the great news is this. President Biden announced that the travel ban for people who were going to get green cards through the embassies, go to do an embassy interview, and once they enter the United States, get green cards. I think it's proclamation, 10014, something like that. That has been lifted. This has been affecting people that were part of diversity visa green card lottery. It's been affecting people who have family members, like, for example, husbands and wives, spouses of green card holders, brothers and sisters of U.S. citizens, but also people who were getting employment-based green cards, who are waiting months and months and a year now to be able to come to the United States to be able to get their green card. They've been on hold. Either the interviews were not being scheduled, or they were not being scheduled, or they were scheduled, but the visas were not being issued. They say we're not allowed to do that. I just spoke with a client yesterday who had a Fiance visa who was not subject to this proclamation, but the embassy mistakenly said they are. So it was a hot mess. But thankfully, the upside is that it's been lifted. But if you're a regular listener of this program, you know how much of a realist I am. Although it's a very happy occasion that this travel ban has been lifted, unfortunately, on the other end, practically speaking, there's no change. Why? Because most embassies are at minimum capacity. They're not even doing interviews for that many people. They're closed. So there's a big backlog that has emerged over the last year. Tens of thousands, maybe hundreds of thousands of cases. It's really massive. For example, I have spouses of U.S. citizen cases. These are cases that are not subject to these bans at all. They were always allowed to get visas. They were an exception to them. They've been pending at the embassy or waiting for an embassy interview for 8 or 9 months, for example, in Turkey. So when you hear the news, the good news, oh, now the travel ban is gone and we could get this, my spouse or my sibling or whoever it is, status, or get their green card interview so they come here. Unfortunately, it's not the case that it's going to have to be like that. It's still going to take a while before they do the interviews. There's huge backlogs, understaffed, shutdowns because of COVID, understaffed because of COVID. So expect delays to continue, but it is still good news. So that's a full breakdown of what is actually happening right now. The law is lifted, but practically speaking, there's not going to be a difference for you for some time when it comes to these kind of cases. I made an expedite request for my biometrics for receipt October. Will it work? Because trial document processing time says 3 to 5 months. Well, first of all, you have to do an expedite request. You have to have a reason for it. So if you're doing expedite requests for biometrics, you're supposed to call them up, and then they call you back up to schedule a time if they think it's appropriate for an emergency. So it depends on what your reason for the expedite is. We don't know what that is here based on the questions you told me. And then on the other end, you say, document processing time, travel document 3 to 5 months. No, it's more like 6 months. Could be longer, could be shorter. But don't really rely on the timelines that USCIS gives you, because they're completely inconsistent. I can't really stick with them. They go all over the place. So it's not something I would rely on. I have a fiance that's stuck in Kabul. My fiance had his interview, but it's stuck. Well, they can be stuck for a lot of different reasons. Typically what you mean is administrative processing, which means they had the interview and they said they're going to think about it more. I was talking with another person who had an interview at the embassy in Pakistan for a fiance visa case, and they said they're subject to the ban I just talked about, for immigrant visa holders, which is incorrect. A lot of embassies are making this mistake. So we're trying to contact them and say, listen, they were never subject to this ban in the first place. What are you talking about? But now, especially with the ban gone for immigrant visa holders, now the thing about a K-1 fiance visa is it's technically a non-immigrant visa, temporary visa, as opposed to an immigrant visa, but it's treated internally as an immigrant visa. So it doesn't make much sense. It might maybe hard to understand for a lot of people. But the reality is, those bans did not apply for K-1 fiance visa holders unless you're in one of the countries like China, Iran, Europe, Brazil, where you're subject to different kinds of bans because of COVID-19. They shouldn't be stuck for those reasons. However, many countries, even before COVID happened, even before Trump and all this stuff like that, this administrative processing would happen, which is you do an interview, then they say we need to do additional review of your case, maybe some background checks, maybe send it back to Washington, D.C. to do some verification. And once it goes down that black hole, it's a mess. So I need to see exactly what happened in your case. And if it's been a long time, maybe the situation that you're required to do is to file a lawsuit against the government for these delays. Now, a lawsuit doesn't mean they're going to approve the case. They may even deny it. But you're saying this is unreasonable delay. It shouldn't be like this. And the embassy has to make a decision. And many times that causes the case to open up and get finished. But it doesn't necessarily mean it's going to get approved. So be aware of that. You should talk with an attorney in private, immigration lawyer that does this kind of stuff to get the best information on how to deal with that issue. Hi, adjustment of status I-485 package delivered to USCIS on February 8th. I-94 admittal date March 6th. Can I stay in the U.S. after March 6th? So here, they came to the United States on a tourist visa. They filed for a green card, and their tourist visa is going to end. And they're asking, can I stay in the United States after my tourist visa ends, even though, since I filed an adjustment of status I-485 application? The answer is yes. When you do file for a green card application form I-485 and it's done properly, you are in a period of authorized stay, which means they'll let you stay here to get a decision. Now, it doesn't mean you have status, so make that known. In these kind of cases, if there's an issue or if they want to, the government can come and either, if you're on a B2 tourist visa, put you in immigration court to remove you or deport you from the United States. They have the power to do that, though they typically don't because they know you're going to have an interview eventually or they're going to deal with you. And once that decision is made, if approved, it's approved. If it's denied, it's denied, and they'll send you back home. They let you alone. Now, the times where it becomes a problem I see is when people have things like a DUI, they get pulled over for driving under the influence or other criminal issues that the government says, you do have a green card case pending, but you're doing this wild behavior. What we're going to do is send you to immigration court to remove you from the United States. So, by general, I do these kind of cases all the time where people are here, they just change their mind, decide to stay here and to apply for the green card. In those kind of cases, once you file for adjustment of status, it's okay to stay here. Just don't do anything wild, as long as the case is properly submitted within the time. So that's something that's really important. No, we get that question a lot. How about asylum cases, sir? I had a biometrics December and waiting for interview. So the biometrics you took for your asylum has nothing to do when you will get your interview. Asylum cases sometimes get done in a few months if you apply it, and sometimes they take years. And you have no control over it. Maybe if you file a lawsuit after a certain time, maybe you can make it go faster. There's some expedite programs that don't really work, in my opinion. Very rarely do they work. But overall, you just have to wait and be patient. So that's what you do with that. Does putting outside of normal processing request delay your case if done multiple times? Okay, so sometimes the cases are taking too long. You go online and you say, my case is outside normal processing times. It's taking too long. If you do it multiple times, what happens? Does it cause your case to be extended? It's not clear. In one sense, it causes them to pay attention to your case, say what's going on, so it could cause the case to move forward. But if you keep doing it, maybe it takes it out because, I don't know for sure, but someone had once told me that if you make a processing time request to say something's wrong with the case or there's delays, the person handling the case gives the case to another officer to review, and it takes it out of their queue and it goes back to them, and it kind of messes things up. So, the reality is if you do it once or twice and nothing goes forward, I wouldn't do it again, and I'll just gap. So you ask once, nothing happens for or just because your case takes too long. Maybe 2 months later, you ask again. And then if you ask again another 2 months, what's the point? It's not going to happen. Maybe you get a congressperson involved, or the ombudsman's office involved, or maybe wait 4 or 5 months to give it some more time. But to repeatedly do it, it's a strategy. There's no correct answer to that, but it's something that's there, and you got to figure out what you want to do, make a decision. It's strategy. Sarah Bailey asks, hi there, I have a DUI. It's been expunged. My application has been denied. Can I request a hearing? What's very important to know is that in immigration, expungements do not matter. They're not taken into consideration. If you had a DUI, you have to mention it. If you don't, it could be potentially fraud. And depending on when the DUI was, what the circumstances were, then yes, they can deny a case. But it really depends on the facts and what happened, the surrounding circumstances are. If you told them or not in the application, you don't want that to become misrepresentation. So Sarah, that's such an individual issue. You have to schedule a private consultation, review your case, do it quick because your appeal period ends quickly. Most likely, I'm guessing you made a mistake by not telling him, but I don't have enough information here to be able to tell you that. So definitely schedule a private consultation with an attorney. After filing and sending I-485, if we work remotely outside of US, our chance of rejecting our NRW case increase? In other words, for working remotely outside the US, do we need work authorization? That's a tricky question. It's not a matter of a chance of requesting. Either you violate your status or you don't. In an IW case, it's what's called it's an employment-based case. There's exceptions for what's called 245I, depending on how much work you're doing or not. But the big question here is, if you're in the United States, but you're working remotely for a company overseas, is this considered unauthorized employment? And there's no good answer to that question. The way the regulations, the statute are written on that, it's very vague. So some interpret it in the government as if, oh, you're working in the United States, you're just physically working, you're violating. Some will say, no, if the source of the money is overseas, you're working for someone overseas, then it's okay. I generally tell people not to do it because it is subject to this kind of, duplicity. It's not clear. Was it not or is it not? So there's no exact answer. Some lawyers will tell you there's an exact answer. I challenge them and say, no, the statute, this is how it could be read differently. So I fear for clients who want to work remotely because it may violate their status. So I tell them usually, don't do it, don't risk it. It is a personal decision, and some lawyers will say, no, it's fine. And again, I know people in the government at the ports, for example, CBP, many times the Customs Authority, if they see you're working in the United States, they'll ban you from coming in. But if you say, no, it's remote work for a foreign company and they're paying me their foreign money in a foreign account, they'll say it's fine. But if you're dealing with USCIS, which is different from CBP, the Customs and Border Protection, the random officer you deal with may not see it that way. So you're this close to getting a green card, don't take the risk. You already sent Form I-485, and hopefully it won't be long before you get your work authorization. You can do whatever you want to do. So maybe just take a break from that. But if you are filing an I-485 adjustment of status based on a work case like that, there's a statute called 245K, which forgives a certain amount of unauthorized work up to 180 days. So really schedule a consultation with an attorney to see the lines of where you're working so you don't get into a hot mess with it. If you really need to work, if it's a job you just can't give up, try to plan out, strategize, talk with an attorney in private. S. Khan asks, I live in Louisiana, but by mistake, I mailed my case to the Arizona address. Does that make a difference? Well, for the most part, if you're mailing something to a lockbox, not a service center, but to a USCIS lockbox and you mail it to the wrong address, they will go ahead and forward it to the right location. It's not guaranteed but that's what they typically do. So, but, it depends on what your case is. If you have a case that's, time sensitive, if you mail it to the wrong spot and your time expires and you lose your spot, you may want to resubmit it to the correct location. So one is they probably will forward it. I can't guarantee that. But if you want to be really safe, maybe you want to send it to the right location yourself, cancel the other case. So we have to see what's going on there. We can schedule a time in private to talk about that more. But with that, we have a couple minutes left. I want to remind you to download the Ultimate Marriage Green Card Guide if you are thinking about doing a marriage case, or already done a marriage case, or whatever it is that's related to marriage green cards. Go to www.marriageimmigrationlaw.com. I'm immigration lawyer John Khosravi. If you are interested in consulting my office, email me and briefly describe your immigration issue so I can see what's going on with the case, and then we can take it from there. Fees do apply for consultations. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.